My name is Robert Walker, and this is the third in my series on the matter of managing insolvency in troubled times. The subtitle to this particular session is The Perils of Inaction. Now, we have a graphic example of such perils in the coronavirus pandemic. Those who acted decisively and quickly have done well, those who didn't have done very badly. The same applies to insolvency. When you're operating a company, and I will deal mainly with companies, though similar ideas apply to personal bankruptcy, when you're dealing with a company, you have certain obligations. And those obligations come with consequences, which are essentially act as negative incentives or disincentives to act otherwise. And those two potential consequences can be seen, those consequences can be seen in two different ideas. There are pricing consequences and prohibition consequences. I'll explain what those mean in a minute. Now, when you're thinking about the duties of a director in insolvency, the words of Justice Barrett Wallace, some 15 and more years ago, are highly relevant. In a matter entitled Chester Trustees Limited, he said this: "The very purpose of the Companies Act, creating a legal entity distinct from its directors and shareholders, is to allow it to engage in business activities entailing risk without exposing shareholders to greater liability than the amount of their investment. The condition of the privilege is that the company be able to pay its due debts. Inability to pay debts triggers a series of consequences." He then followed that up a couple of years later in a matter with the title Mountford and Tasman Pacific Airlines. In that matter, he said, "The obligation to maintain solvency is imperfect because breach does not per se attract legal consequences for the directors, but it is nevertheless an obligation because it is the premise on which there is unconditional entitlement to continue to trade." Now then, what does he mean by that? What he's talking about is the complex and nuanced decision making that a director must make, or when they're staring down the barrel of insolvency, or they're imminently insolvent. What they must do is stop acting in the interests of the shareholders, whose interests have gone, which is the meaning of insolvency, and start to act in the interests of the creditors. Now, basically there are two choices at that point. The directors could abruptly stop the loss for the creditors at that point. There's a risk in doing that, and that assets that do exist may be disposed of at fire sale prices, or destroy things like goodwill. So it may not be in the best interest of the creditors to do that. They may be better off if the business continues in operation. It's certainly true of suppliers. It's certainly true of employees who need a job. So, the second choice, sometimes that might be the right answer, but the second alternative may also be the answer, which is to continue the business and operate it to try and maximise the value of the assets and the potential for the business to survive. Now, what you cannot do in those circumstances, which is actually quite common in New Zealand, is to engage in what I call involuntary liability substitution. What I mean by that is the circumstances where creditor A has an obligation due to it, a liability, that is to be settled now, but there's no money. So what can be done is that a supply can be taken from supplier B and the money realised and paid to creditor A. What has happened is there's a shortfall of liabilities, but it's been transferred from A to B. That is definitely not allowed. So you certainly can't do that. The second sin might be seeing the world through rose-coloured glasses. Now, a character we've met before in this series, Mr. McCaw from David Copperfield, is guilty of rose-coloured glass optimism, recklessly so. And he says this: "Walking along the street, reflecting upon the probability of something turning up, of which I am at present rather sanguine, I find a young valued friend turn up. No, things don't turn up, and Mr. McCorver is the literary proof that it doesn't turn up. So over-optimism is bad as any sin that could be committed. Perhaps an even more serious sin is the prolongation of the company, purportedly in the interest of the creditors, but really in the interest of the director. That carries with it potentially very serious consequences. So now let's turn to the consequences. We'll deal first with the concept of prohibition, as I identified before, one of two classes of disincentive. By prohibition, I'm talking about potential for criminal prosecution. I wouldn't want to overemphasise the possibility that would happen, particularly in New Zealand, as our authorities are rather timid in that respect. But anyway, it's a possibility, and may become more so in the aftermath of the recession we're about to go into. So, what sort of criminal consequences are there? Well, I'm going to identify two. The first is expressed in Section 380 of the Companies Act, and its title is Carrying on Business Fraudulently or Dishonestly Incurring Debt. And it says, or at least preamble to it says, every person who is knowingly a party to a company carrying on a business with intent to defraud creditors of the company or any other person or for fraudulent purpose commits an offence. Now, you can see lying in there would be some difficulties for a prosecutor. They'd have to identify the intention of the person to defraud or to incur debts they knew weren't going to be paid. But if a company's insolvent and you, the director, know that, then I say prima facie it's not difficult to demonstrate the mens rea or the intention in that case. However, what happened in the aftermath of the last recession is the policymakers down in Wellington didn't think that Section 380 was sufficient. They introduced a new crime directly in the director's duties part of the Act. Now, the section I'm talking about is Section 138A, and it says, a director of a company commits an offence if the director exercises powers or performs duties as a director of a company, A, in bad faith towards the company and believing that the conduct is not in the best interest of the company, and B, knowing that the conduct will cause serious loss to the company. Now, the sorts of things I was talking about before, about prolonging the life of a company purely in the interests of the director or the shareholder, or as they're common now, both, would offend against that particular section. Again, difficult concepts in it. Is it likely to be prosecuted? Perhaps not. Rather interestingly, there was a private members' bill introduced into the legislature late last year to amend the Companies Act, and it was to create a safe harbour option. The purpose of the bill was to create a safe harbour option with respect both to 380 and to Section 138A. Now, it sets out a set of conditions that basically says that if the company is insolvent and the director carries on, then and they do so to try and protect the various interested parties, the stakeholders, they will be immune from prosecution under either of those two sections. Now, that's good because that fits rather neatly with the idea of compromise that I'm going to talk about over time in this letter, in this series. Now, I do think it presents a danger if it's enacted, because if you don't do what it says, then you're almost certainly guilty of the offences. Anyway, those are the potential criminal consequences of carrying on when you shouldn't. Now, the second class of event, or disincentive that I talked about, was referred to as pricing. What that means is that directors can be subject to personal financial consequences of carrying on or being insolvent and not acting in the best interest of the creditors. Now, generally those consequences come about when a company is put into liquidation, and there are rights at that point belonging to creditors and liquidators. They are set out in Part 16 of the Act, which governs how liquidations are carried out. And there are two sections of relevance that I will identify. Section 301, which can be invoked by the liquidator or the creditor, don't need a liquidator for it, just need to be in liquidation. They can apply to the court to hold a director personally accountable for breaches of duties, those duties being those set out in the directorial duty parts of the Act, or any other tort that may be applicable, or breach of trust. So they're quite broad in its scope, and it is the creditors are entitled to do it. Do creditors do it very often? No. Do liquidators do it reasonably often? Yes. One that is particularly important to me is one that is a liquidator-only remedy, which is set out in section 300, and that is the right of a liquidator to apply to a court to have a director compensate the company and the creditors for failing to keep proper accounting records. So you cannot pretend that you didn't know you were insolvent by failing to have proper records. It's a very serious consequence if you don't keep the records. Now, those things are particular to Part 16, but there are other potential consequences that lie elsewhere in the Companies Act, and those powers also belong to a liquidator. I'm thinking, for example, of clawback of invalid distributions, set out in section 56 of the Act, or indeed the potential for a liquidator to avoid transactions with the director, which can have serious consequences for the director, as set out in section 141, and I know that works because I've done it. Now, those provisions also belong to the director, but the director is not likely to invoke it against themselves. So it is most likely going to be a liquidator who would do it. Again, I would not wish to overemphasise the probabilities of these things happening to people who operate failed companies and have done nothing about it, but it does happen. As you can see, it goes back to 15-20 years now, and it's likely to increasingly happen because of two things. Firstly, there are third-party funders that have come onto the scene in the last few years, and secondly, the potential for liquidators to sell causes of action is there. Indeed, in the aftermath of the last Great Recession, it might even been before, the Parliament specifically encouraged liquidators to sell causes of action. It's normally not allowed, but in that case it is. So, there you can see that there are potential for very serious consequences, criminal consequences and financial consequences for directors who do not act in the best interest of creditors when a company becomes insolvent. What I'm going to do is, in the next session, I will talk about the first three options that are available for managing insolvency of companies. They are liquidation, receivership and voluntary administration. And that is before we talk about compromise, which is something that I favour. Having said that, I think it's very important to realise that all of those persons occupying those offices, those statutory offices, are obliged to report crimes to the registrar. So bear that in mind. Please, if you wish for written material, look below the video and you will find ways to acquire it. Thank you very much. Bye.